Recall Natasha without delay. Falana warns Senate. Say dem must obey court as appeal no fit stop wetin dem call non-binding advice. Dis na Sinok Media. We wan thank all our viewers. Abeg, for those of una wey never subscribe, make una do so now. Put on your notification button. E go give you notice of our update. Make you like, comment, and share our videos. Human rights lawyer and senior advocate of Nigeria, Femi Falana, don yab Nigerian Senate say dem no wan recall Senator Natasha Akpoti-Uduaghan, even when clear court judgement don tok say her 6-month suspension no dey constitutional and e too much. Justice Binta Nyako for Federal High Court Abuja, for judgement wey she deliver on July 4, 2025, don rule say the suspension of the lawmaker wey dey represent Kogi Central not only dey too much, but e still violate the principle of democratic representation. The court tok say if you suspend senator for 6 months for legislative calendar wey get 181 sitting days, e mean say the constituency no go get voice and e go kill democracy, since the representative go only sit for 1 day. Na make the court say e dey too excessive and e dey unconstitutional. For wetin Falana describe as brazen act of contempt, the Senate still dey do anyhow and dem no gree reinstate the lawmaker. Dem dey argue say the certified true copy (CTC) of the judgement no get compulsory order wey go force dem to recall suspended Senator Natasha Akpoti-Uduaghan. As Falana dey react, e insist say the decision of the Federal High Court, including the recommendation for the recall of Senator Natasha Akpoti-Uduaghan, e dey bind for Nigeria constitutional law. E dey important, according to am, to talk say since the learned trial judge don determine say Senator Natasha Akpoti-Uduaghan suspension dey excessive and unconstitutional, the consequential recommendation of the court dey bind on the members of the Senate. Na so Falana put am, as in dey quote section 318 of the Constitution. Falana point out say court decision no be only judgement or order, but e include recommendation too. E come still remind dem about the Court of Appeal decision for People's Redemption Party (PRP) versus Ondo State Independent Electoral Commission and others 2018, where the court tok say any judicial determination na decision under the Constitution. Since Justice Nyako don settle the wahala about the legal validity of the 6-month suspension of Senator Natasha Akpoti-Uduaghan by the judicial decision, and e don advise the Senate to recall her without any condition, dem no get any excuse to dey treat the valid decision of the Federal High Court like say e no matter. Na wetin Falana dey tok be dis. Falana come still invoke section 2873 of the 1999 Constitution wey mandate say all decision of the Federal High Court go dey enforced for any part of the Federation by all authorities and persons. According to the senior lawyer, the appeal wey Senate still carry go Court of Appeal na unwarranted and e dey ridiculous, because the chamber dey insist say the Federal High Court just give advice and no be binding directive. According to am, wetin be the legal basis to challenge decision of the Federal High Court when dem dey claim say e no dey binding on the Senate? Or why Senate dey beg Court of Appeal make dem squash and set aside the so-called advice? Falana come dey ask. Im dey maintain say as Senate dey ignore the clear determination of competent court and still dey proceed to appeal wetin dem claim say e no dey bind, the senate don carry unnecessary disgrace put for themselves and the whole process. Country pipo, wetin learned silk Femi Falana dey tok so na timely counsel for the Nigerian Senate to heed and to do the needful, because e con dey appear say the lawlessness of the Senate e don dey so glaring that e con dey put the Senate as the legislature against the court wey e be the judiciary, and e no dey tell well if lawmakers come become lawbreakers. The point of law wey Falana dey address for here so, e dey clear even to a layman. You say the court give advice and the advice no dey binding on you, on the Senate. At the same time, you dey take appeal against the advice when you say e no bind the Senate. That's why Falana dey say they carry unnecessary disgrace put for themselves and the whole process. This stage of this matter now na where the Senate president go look at the bigger picture, make e no look am as himself dey fight. Now na the Senate the country dey see, and even the world dey see say dey fight Natasha. So if the court give an advice as they call am and a ruling as the judge know, the Senate suppose to show say e dey defer to the court so that they go reinstate Natasha. But you dey appeal against the ruling of the court. E con dey make am like some people dey talk say the Senate president, for e blind rage to punish the suspended senator, e don dey reduce the Senate to a plaything. And e come be like say even the lawyers for the Senate, dem no understand the intricacies of wetin dey play out. That na why no resentment don come from the Senate to say no, enough of wetin dey happen, make the Senate obey the ruling of the court so that Natasha go fit resume plenary. At least a part of the matter go come die down. But no, Senate dey appeal wetin dey say e dey non-binding and advice. But the learned silk don prove am say for law dem suppose to obey wetin the high court judge don talk. Country people, our Senate e still remain our Senate, so or the Senate don become Akpabio and Akpabio don become the Senate. How una see this counsel or advice wey Femi Falana don give so?